Hello, my name's Charlotte Geesin, Head of Employment Law and Business Immigration at Howards, and this is part one of our redundancy focus video mini-series. During the course of this video, I'm going to take you right back to the statutory definition of redundancy and explain to you what it is we mean when we talk about work of a particular kind in the context of a redundancy situation. Very broadly speaking, redundancy is used as a means of describing a situation in which an employer has decided to reduce the number of its employees, either within the business as a whole or at a particular site, business unit, or within a particular department for a number of reasons. And whilst that sort of broad general description is there or thereabouts, it's very important to understand what the statute actually defines a redundancy as. Because if an employer who makes redundancies fails to demonstrate that they have met with those requirements of Section 139, then it is highly unlikely that any redundancy dismissals will be treated as lawful and fair. The relevant legislation is the Employment Rights Act 1996, and it's Section 139 of that legislation where employers can find the statutory definition of redundancy. The definition is not overly easy to paraphrase, and I would recommend that you have a look at it, and particularly if you are contemplating making redundancies at any point, to ensure that you're able to comply with that. But in essence, where an employer can show that it has or intends to have either a reduction or a cessation in work of a particular kind at a particular location, then it is likely that it will be able to establish a genuine redundancy situation for the purposes of that section. I've just said there, a genuine redundancy situation, and I think employers, employees and lawyers alike frequently speak of there being a redundancy situation, but I think in reality that's more of a convenient shorthand for the states of affairs which are set out in Section 139 of the Employment Rights Act. And I think if we seek to narrow down further what we mean when we talk about a redundancy situation, there are probably three main categories of situation through which a redundancy can present itself. The first, I think, is a business closure, and that's where obviously an entire business closes, completely ceases operation. All employees who were employed are made redundant. Very straightforward, I think, as a concept. The second is a workplace closure, which isn't quite as drastic as a business closure, and it's more about where a part of a business closes, either a site or a department perhaps ceases to be. And then thirdly, and perhaps most commonly, a redundancy situation can present itself where there is a diminished requirement overall for a business to employ employees to do work of a particular kind. Whatever category of redundancy situation you may find yourself dealing with, it is still vitally important that you are able to tie it back to that overall reduction, cessation of work of a particular kind definition that's provided for by Section 139. Now, an employer is perfectly entitled to make its own commercial, operational, business decisions when it comes to reducing or ceasing work, and also when placing its employees at risk of redundancy. A tribunal is actually prohibited from sort of delving too deeply into a business's rationale. However, an employer does still need to have regard to that genuine need to make redundancies. And I think in practical terms, in order to best position yourselves, not only with your employees, but also with a tribunal in the event of a future dispute, what you should be doing at the outset of any potential redundancy situation is some business planning. ultimately. I mean, what you need to do is look at the main driver that you are facing, that is in your minds necessitating a reduction in headcount, and then working through the figures that sit behind that, or the facts, the operational facts that help to bring that business case, that business need to make redundancies to life. If you do that, it will obviously help to focus your minds. It will, in theory, help you to demonstrate to a tribunal that you had proper regard to Section 139, and also to demonstrating a genuine need to make redundancies. But actually, when you start off with the consultation with the affected employees, it will allow you to explain to them in a very objective, commercial fashion why you're having the conversation with them that you're having. It allows you right from the outset to remove any subjectivity, to make this about a business need as opposed to an individual employee problem, which in my experience tends then to help the consultation process, which I'll be talking to you about in part 2 of this redundancy focus mini-series, run far more smoothly, which in theory then should reduce your overall risk of getting sued once the whole process is concluded. If we look at that third category of redundancy situation, i.e. the reduced need for employees or the same number of employees to carry out work of a particular kind, then, if we seek to tie that back in with the legislation, a dismissal will be by reason of redundancy in this situation if it is wholly or mainly attributable to the diminishing requirements of the business for employees to carry out work of a particular kind, either in the place where the employee was employed or within the business generally. On that basis, then, a dismissal may be made by reason of redundancy in the following 2 scenarios. There may be the same amount of work of a particular kind available, but a need to have fewer employees doing it. I suppose this might be thought of as the classic situation in which the employer decides to make better use of its resources or to implement cost savings measures to help it see through a tricky financial time. Second example is where there's less work of a particular kind and fewer employees are needed to do it, i.e. the work shrinks and so does the headcount. This may occur when a customer perhaps reduces the amount of its orders, or there just isn't as much demand for a particular service to be delivered overall. When we talk about work of a particular kind, it's really important for an employer to understand what this means, because if an employer fails to properly identify that reduction or cessation in work of a particular kind, there's a very real risk that the requirements of Section 139 won't be met at all. Work of a particular kind isn't set out anywhere in any defined terms, which perhaps won't come as any surprise. But there is a lot of case law which sort of addresses the question of what is work of a particular kind. And I think if you have any doubts at all as to what work of a particular kind is and how that impacts upon your decisions to pool certain individuals, again, the pooling being something which I'll be talking to you about in part 2 of this mini-series, then you should take advice, because it's vitally important to establish that work of a particular kind, like I say, in order to meet with the basic statutory requirements. Generally speaking, though, when you're looking at work of a particular kind, the focus is on the tasks which are attributed to that work and or the skills which are required to do it. In the case of Amos, the Max Arc Limited, which is a case from 1973, but which remains good authority today, it was held that work of a particular kind means work which is distinguished from other work of the same general kind by requiring special aptitudes, skills, or knowledge. And in this case particularly, it was held that sheet metal work was not of a different kind to black metal work, even though the rate of pay was higher for one. What the court held there was that it was the skills required for the work rather than the terms and conditions attached to the employment which had to be considered. And I think whilst that principle seems pretty clear, as with any redundancy, it will always be a matter of fact for each tribunal to determine. So I think what you can sort of take away from that is actually where you have a sort of department within which you have different categories of employee, different job functions, it's not necessarily going to be the case that if you need to make cuts from certain parts of that department, that every single employee is going to be placed at risk of redundancy. It is more likely that what you will be able to do is narrow down your thinking when it comes to that wider department and place certain groups of employees at risk of redundancy only. That won't necessarily be the case in all situations, of course, and it may be that you end up pooling a whole department, but what I'm saying is it might not be the only approach that you have to take. In addition to focusing on tasks or skills when looking at work of a particular kind, the courts have also held that actually a level of experience might also be relevant for helping to determine what is work of a particular kind. And in cases where the skills required for the job are closely bound up with the employee's level of experience, it might be that work which looks similar is in fact of a different kind to another. And the leading case on this point is that of BBC versus Farnsworth. This was an employment appeals tribunal within which the court held that the dismissal of a Mark I producer and a replacement by a more experienced Mark II producer did amount to a redundancy situation, as the level of experience of the Mark II producer was found, as a matter of fact, to be in a different league to that of a Mark I producer. So in practice, what that may mean for your organisation is that you have a team of project managers, but going forward, actually you want to restructure that team and instead have a head of department with fewer project managers. The removal of, or the replacement rather, of some of the project management function by a head of department function could therefore, using the principles of the BBC versus Farnsworth case, amount to a redundancy situation, a genuine redundancy situation, on the basis that there is a reduction in the requirement for the project team leader work to be undertaken. A vexed question when it comes to the matter of work of a particular kind is whether or not there is a distinction between part-time and full-time work. And there aren't actually any satisfactory authorities on this point, although it seems highly unlikely that an employer will be able to distinguish between part-time and full-time work in distinguishing work of a particular kind. The best advice that I can give you at this point in terms of working out whether part-time or full-time work is work of a particular kind is indeed to take advice. Although a redundancy situation will generally be quite obvious to identify, that's not always the case, and there is a very fine line between a redundancy situation and a restructure situation, which doesn't necessarily necessitate a redundancy dismissal process, but would actually necessitate a consultation exercise geared up to obtain your employee's consent for their terms and conditions of employment to be varied. The question of whether a reorganisation is, however, in fact a redundancy exercise is fact specific, and there's plenty of authority on the point to say that actually a redundancy situation might not only arise where there is a poor financial situation underpinning a need to reduce headcount. It might actually be the case that a business is doing fantastically well, but because it decides to reorganise or restructure the way in which employees are employed to carry out work of a particular kind, the result of that is that fewer employees are needed overall in order to perform the same functions. I think, again, if you feel that you are treading the line between redundancy and reorganisation, to take some advice in terms of what your options are. Sometimes an employer's proposal to change terms and conditions may give rise in itself to a dispute about whether or not the changes actually should have been addressed by a redundancy dismissal as opposed to a variation to terms and conditions. So when a case like that presents itself, employers will obviously likely argue that the circumstances necessitating change in T's and C's fell short of meeting the statutory definition of redundancy, and therefore that the employees were dismissed for refusing to accept the changes on grounds of some other substantial reason, therefore not being entitled to a redundancy payment. But the dismissed employees will likely argue the opposite, which is actually the changes were so substantial that they were in fact dismissed by reason of redundancy, that their SOSR dismissal was unfair, and that actually they should be entitled to a redundancy payment. I think when it comes to the line between redundancies and restructures and the correct approach to take, because decisions in this area are so fact sensitive, and because the employee fallout can be quite difficult to reconcile and manage, again, I think the best thing that I would say to you at this point is to take advice in terms of your options and in terms of the best way to approach a situation like that. When we look at section 139 of the Employment Rights Act, we know it talks about a requirement for there to be a reduction or a cessation in work of a particular kind. And when an employer is looking at placing employees at risk of redundancy, one of the things that they will often do, and indeed will often be advised to do, is ask employees from the outset if anybody is interested in taking voluntary redundancy. Voluntary redundancy can be an exceptionally useful course of action for an employer to take in terms of avoiding, consultation processes, and also in terms of avoiding upsetting employees unnecessarily. Nobody likes to be told that their job's at risk of redundancy, and the sort of calmer you can keep your employee body, the better overall, without a doubt. When it comes to voluntary redundancy, though, it's important to note that a voluntary redundancy is still classed as a dismissal in law. Even though the employee has to ask to be made voluntarily redundant, they have to apply for it. It's not a resignation, it's still a redundancy, and the employer is still classed as having dismissed the employee. So on that basis, the employer, in order to ensure that that voluntary redundancy can be classed as fair, still needs to show that it came about because of a reduction or cessation in work of a particular kind. Therefore, the only people who can be offered voluntary redundancy are those people whose roles are affected by the overarching need to make redundancies in the first place. It's not appropriate for an employer who needs to make cuts across the business to put a general announcement out to every single employee asking them if they want to take voluntary redundancy, if it isn't the case that every single person's role isn't at risk. Employers who accept voluntary redundancy applications from employees whose roles weren't actually at risk of redundancy in the first place may find themselves on the wrong side of an unfair dismissal claim. I hope that you have found this video useful in terms of understanding the statutory requirements for a redundancy dismissal. If you join me in part 2, I will be talking to you about the redundancy consultation process, how you correctly, how you select fairly, and how ultimately to avoid an unfair dismissal claim. I hope to see you there.